Thank you.
Yeah, cheers.
This hearing is the matter of case number CFI 098-2021 before His Excellency Justice Ali Al-Madhani. The hearing is being held by way of video conference at the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Clyde & Co. Lead counsel is Nicholas Craig, QC. The defendant is represented by HFW. Lead counsel is Zoe O'Sullivan, QC. Thank you, Your Honor.
Well, Mr. Craig, I gotta repeat myself again. Your application, and it's your opponent will, yeah, as you have seen their submission that comes to before me today or last or afternoon. I've read it this morning actually.
This morning.
Yeah, this morning. So you know the story. It's we're discussing the urgency with the merit of the application itself.
Yes.
My lord, sorry, could I just intervene? As I understand it, nobody is asking you to decide.
Oh, we have a party. I can see another party over there.
My lord, as I understand it,
is that your team, Mr. Craig?
I'm sorry?
Is that your team in the?
I don't think so.
Okay, so I've just seen I don't know, whatever.
My lord, I just wanted to say, I don't think anyone is suggesting that you should hear the final application for anti-suit relief today. The question is simply whether you should grant an interim injunction pending the final hearing.
And what is exactly interim?
Well, it depends when the application is listed. We've suggested that it can be listed to be heard next Friday on the 16th. I think the claimants are suggesting it could be heard at the end of October.
Oh, I think 17th or something. Okay.
Yes.
Okay, thanks for the clarification. Yeah, Mr. Craig.
Thank you, Your Honour. I mean, first of all, happy birthday. I understand today is a special day.
Oh, thank you very much.
And as you know, there are two applications, in fact, before the court. The first is for an anti-suit injunction, and the second is to join ABIS as a party. I'm intending to deal first with the anti-suit injunction. And as set out...
Excuse me, Mr. Craig, I'm not alerted that I would be dealing with the joining extra parties in this case. I'm only alerted by the registry that I'm going to be dealing with ASI application only.
Okay, my understanding was that the joinder application was...
Only this morning I was told there might be discussion before me about anti-suit. I'm not sure of whether that application is fully pleaded on time with a sufficient time given to your opponent.
In relation to the joinder?
Yes.
Yes. Well, I mean, in relation, I'll come on to that at the end, if I may.
Okay, well, then let's deal with them one by one.
I'll deal with the anti-suit first, and then deal with the joinder application. I mean, in relation to the anti-suit, as I set out in our skeleton argument, the underlying proceedings in this court relate to claims by ABNIC for declarations of non-liability under two policies of insurance. Those proceedings were issued in the DIFC court last November, it's almost a year ago, and Horizon contested the jurisdiction of this court. It lost that contest. It then sought permission to appeal that decision, which was refused in the middle of August this year, and it has made another application for permission to appeal that decision to the Court of Appeal, which is currently pending. Meanwhile, the committee of the Insurance Authority, to which Horizon made a complaint under the policies, ruled it did not have jurisdiction over the dispute. Now, on the 7th of July, so just under 2 months ago, Horizon and its subsidiary ABIS commenced proceedings in the Sharjah courts, and it seeks in those proceedings to overturn the decision of the committee of the Insurance Authority, as well as and to return it to another committee, or alternatively, it seeks an indemnity under the policies. The issues raised by it in those proceedings, the Sharjah proceedings, have either already been determined by this court or are issues in these proceedings.
Hang on. I think that is what's been decided by the DFC court, and maybe not even finally, the jurisdiction, because as far as I can see, the defendant is still battling this jurisdiction to the to the maximum, and they want to reopen the hearing, and they, filing grievance against Chief Justice decision by rejecting the permission to appeal. So the case still might be heard.
Agreed.
And we didn't know jurisdiction might take another direction, maybe.
Yes.
So no finality. So nothing been decided yet. Yeah.
Well,
so I think that should be starting point. No merit, not jurisdiction even. It's not final. We don't know.
Well, as it stands, this court has jurisdiction. And until such time as an order is made, pursuant to which the decision of Justice Roger Giles is overturned, this court has jurisdiction, and these proceedings carry on with this court having jurisdiction. Yep. Now, in those proceedings, the parties have exchanged memos, and amongst other things, my client Abnick have taken the position that the Sharjah court has no jurisdiction by reason of the proceedings in this court. Now, the matter is listed tomorrow before a judge of the Sharjah courts. Now, at that hearing, the judge may give, as I understand it, may give directions, may question the parties, or refer the case to an expert, or it will stay the case. I mean, Your Honour knows fully well what happens at those sorts of proceedings. And therefore, decisions can and may be taken in connection with the conduct of the case. And it's not correct to characterise it as purely administrative, which is what is suggested by Holmans and Ms. Sullivan. And that's clarified in exchange with Holmans this morning. It's also not correct that the parties will not attend tomorrow. The parties are free to attend the hearing tomorrow and to make submissions. In other words, absent an order, Horizon and ABIS can appear tomorrow to advance their position in those proceedings. Now, the application for the anti-suit was issued on the 29th of August for a final order restraining the defendants from continuing those proceedings. That application was served on Horizon on the 30th of August and on ABIS on the 31st of August, pursuant to the order of His Excellency Justice Maha al-Mehri. So more than 3 days have passed since that application was served. Following service of that application, we sought undertakings from the respondents that they would agree to postpone taking any further steps in the Sharjah proceedings until the application for an anti-suit injunction had been finally determined. That request was made twice, firstly on the 2nd of September and again yesterday, 5th of September. Both times it was refused. In other words, Horizon and ABIS have no intention of slowing down matters in the Sharjah courts until this application is determined, and they have no intention of not going before the judge tomorrow. So we say unless they are restrained by this court, those proceedings will just carry on, and Horizon and ABIS will carry on pursuing those proceedings, which we say is vexatious and oppressive.
So if I may understand what you're saying in summary, you want this court to restrain Ms. Sullivan's client and even the party that got to be joined next, not to appear before Sharjah court or do something or drop their cases or in Sharjah. Is that what you want? So this is the interim?
Yeah. On the final basis, the application itself will require them to not pursue proceedings in Sharjah at all.
And then until the final determination of the anti-suit injunction?
No. So I apologize.
Or what?
The interim application is just that they don't take any further steps in those Sharjah proceedings.
But how? Just tell me how, because I don't know if you know this Sharjah and UAE federal system, that the court is in control of the proceeding and the hearing and the giving the date. And you lawyers, whether you agree to come, not to come, they never consider lawyers' agenda. That would happen in the local courts. It's unlike the DFC or any common law court in the world where parties are consulted when the hearing or procedures got to be dealt with. I mean, the UAE court usually, I mean, forgive me for speaking from experience. I've spent 11 years working at that system. What the system do? They don't care about lawyers. They will set a timetable. You either attend, or the court, or you gotta face the consequences of not attending. That's how it works, unfortunately. I mean, we'll be realistic. I'm talking frankly, freely before both of you. And
yes.
From that, I mean, just imagine how the restraining order, how it's going to work.
Well, for example, we understand that they could ask for a jointly for a stay of those proceedings pending determination of this application.
One thing, yeah.
Yes. Well, so therefore, that is something which they could readily do to stop the progress of those proceedings.
Okay, I see. And another thing, what they could do? What else they can do? Drop the case completely.
Well, that ultimately is what we are seeking that they do. And to the extent that, for example, they could restart the proceedings, then we say that that would be what is required. They need to take steps to basically ensure that nothing happens tomorrow. That's effectively what we're seeking.
I see. To be honest, I have a much better understanding of your application now than half an hour ago.
Okay, I'm grateful. Yeah. Now, just in connection with our application, there is no dispute that we have a good arguable case for an anti-suit injunction. So in other words, it's accepted by Horizon and ABIS, we understand, that there is a good arguable case that it is acting vexatiously and oppressively in bringing the Sharjah proceedings.
Well, I don't think Ms. Sullivan would agree to that, but we'll wait until we hear from her.
Well, I just to clarify, I think it's slightly different. What we've said is we're not disputing that there's a serious issue to be tried, which I think is a slightly lower hurdle. We haven't said good arguable case. But yes, we're not suggesting there's not a serious issue to be tried when the application becomes before the court in due course.
Yes, and that issue is whether or not the conduct of Horizon and ABIS is vexatious and oppressive. That is the issue.
Well, I see. I mean, let's break in here. I mean, let me move to Ms. Sullivan side. I mean, I would, if you allow me to ask you, I mean, what tactic are you taking? Let's say you said you're less fortunate. You're before the DFC court by somehow, okay? The claimant brought you to this trap, okay? DFC court, maybe you don't like. Let's talk about the future of this litigation, okay? The full future. You will be fully engaged with this, defending this anyway, whether in Sharjah, in DFC, in London, or arbitration, okay? My question, first of all, why can't you, sit with Mr. Craig and discuss this venue where you want this battle to be resolved? One thing, and why don't you, between you, yourself, and your client, Mr. Craig will be there as well, discuss all options of this jurisdictional challenges, okay? But why don't you discuss all options before you, discuss outcomes, and conduct of every venue that you think in your mind, and then as a smart lawyer between you, your team, and then with your client, you will come to conclusion what is the best available venue for your client interest and even your law firm. Well, if you go to the Sharjah, you got no way you can represent your firm at this level, and you understand that. Well, I'm saying, I'm not forcing you, but I would like you really to keep that battle aside and think of the best interest of the future of this case for your client. I'm sure there is a case to be determined between you somewhere else, and now it's in your control. I mean, you know what I mean? I'm not saying choose DFC. You could both together choose somewhere else. You could go to London. I don't mind, believe me. Okay, I would accommodate as long as you both agree with the consent of your client. What we all need, that your dispute is resolved in the best way. I would advise you go to a venue where the outcome is foreseeable. That's my advice, Mr. Sullivan. Okay, this is as an introductory. Okay, That one,
It's always a very eminently sensible advice. Can I just say, firstly, I myself can say very little about this case because I'm coming in an emergency last night because my colleague, Mr. Hogan, who's instructed on the case, has had an accident. So I myself can say I don't have any instructions about.
But no, he would hear this, Nick. So he would hear
I mean,
me.
I'm sure your lordship's observations have been heard by those instructing me here on this call. The problem is, my lord, is that the parties have not been able to agree. They have radically different views of where the appropriate jurisdiction should be. And obviously, everything would be wonderful if parties could agree. But as sometimes happens, and has happened in this case, the parties have not been able to agree, and therefore the court is going to have to decide that. Now, what's happened is that my learned friend's clients have issued their anti-suit application, and we say we want that to be heard as soon as possible. In fact, we suggested it should be heard this Friday. That was rejected. So we're now suggesting it should be heard next Friday, that's the 16th. So we say, well, let's get on with it and resolve it one way or another quickly. What we do object to is this application, which has been sprung on us without any proper notice for an interim order, where there's absolutely no case whatsoever has been shown for interim relief. No case has been shown for any prejudice resulting from tomorrow's proceedings in Sharjah. And as your lordship has already recognised, there's no point you making an order because the Sharjah court isn't going to pay any attention to what my clients say. And we say that it's quite wrong for them to come to court without any proper notice and saying, actually, we applied for a final relief, but actually we've suddenly decided we want interim relief. When there's no basis for an interim urgent interim injunction. The right course is for this court, we say, to make directions. If the parties want to exchange evidence, that can happen during the course of next week. We'll have a hearing next Friday, and then the position will be resolved with certainty. I mean, it's the claimants who are saying it ought to go off till the end of October. I mean, it's you know, we're saying get on with it.
I see.
I mean, there is
only
prejudice.
There is only slight small correction for this. I mean, as Mr. Craig has said, if you both agreed that you could adjourn the case until a certain date, usually the court agree because they're already fully busy with that. So they would celebrate if you just tell them we need to adjourn this case until unknown date.
But question of any adjournment.
I understand.
The ASI itself has not been listed. I mean, last week the claimant was telling the registry must have an urgent determination of our ASI, but yesterday my learned friend served a skeleton saying, oh no, that can't happen until evidence has been exchanged and there should be a hearing in October. He says, oh, what we're actually asking for is interim relief. So in my submission, this application should never have been made. The other side should have recognised there was no need for interim relief. We could simply have agreed directions for the hearing on the 16th of September or the 17th of October or whatever. But what is not justified on the evidence put forward is any order for interim relief.
I see. As we are here, all we're here, okay? Doesn't matter how this is brought to me, okay? I'm listening. I'm managing this case now. What I would like to, the last things I want to do, I mean, allow two cases run in parallel. The cost is not in favor of anyone. I don't know. I will not discount your chance with the DFC court to contest of jurisdiction, Ms. Sullivan, too. And I don't know what's going to happen. I mean, good luck with both. I mean, I don't know what's going to happen, but I would say that. I mean, initially, I mean, it's not an opinion, but anyone could see that you're already battling this. In that case, it's just about to start. And if you stuck finally with the DFC court jurisdiction, why didn't you just see it? Despite the fact whether this application is brought in the right way or the wrong way or with procedures irregularities, okay? But let's look rationally. Yes, why didn't you go to the judge in charge tomorrow and say, well, Mr. Judge, we do have issue with the DFC court. We're not happy with that court. Yes, we're trying to kick it away from our jurisdiction, but we just need, let's, for example, 1 month or maybe 2 months. So at least we will see where the court of appeal going. And then your case is still there. I mean, both parties, let's say, being cost and effort as preserved, you know what I mean? And then you still can, that venue is available for you until the anti-suit injunction is decided or whatever decided. I don't know. You might win both. We'll never know. But you didn't have to battle it, yes.
My lord, the position is this. There is an ongoing dispute between the parties as to whether this claim should be tried in whether the IFC court has jurisdiction or whether the Sharjah court has jurisdiction, and ultimately the insurance authority. That is a dispute where the hearings, the applications have not yet been exhausted. That is still live, as your lordship has observed. So the claimant, as it is entitled to do, has sought to resolve that by bringing an anti-suit application in this court. They're not asking you to decide that today. They're saying that should happen at the end of October. We're saying it could happen next week. Nobody is asking you today to decide which court has jurisdiction. And it would not be appropriate to do so because my clients haven't had proper notice, opportunity to put in evidence or anything like that. And nobody's suggesting that will be appropriate. The only question you're concerned with today is whether there's a need for urgent interim relief preventing us doing anything in Sharjah between now and the 16th of September or the 17th of October or whatever date is listed for the hearing. And we say not, because we say all that's going to happen in Sharjah tomorrow is an essentially administrative action. The case file is still with the case management department. It's going to go before the judge of first instance. All he's going to do is review whether the file is complete. If he thinks it's complete, he'll adjourn it for a short time and refer it to a judge of the court of first instance. It hasn't even been referred to the court yet. I mean, in theory, there are various powers. He theoretically has powers to appoint an expert, for example, but he's not going to do that. My instructions are that simply never happens. What he's going to do is look at the file, see if it's complete, adjourn it for a short period so it can be referred to the court case manager to the court of first instance. Nothing of any significance is going to happen in Sharjah before the hearing of the claimant's application. Their job is to persuade you that they will be irrevocably prejudiced if you don't make an order today. They haven't begun to discharge that burden. They put in no evidence at all to show why they will be prejudiced. You've heard some submissions from my learned friend this morning without evidence, but even he isn't able to show that in what sense are his clients prejudiced if the judge makes an order referring the court to the file to the first instance judge in Sharjah. Absolutely nothing. Then we can have their hearing of his application in a week, we say, in a month, he says, and then we'll know what the position is. But you don't have to decide today whether it should be Sharjah or DIFC. All you're being asked to do is decide whether there's a case for urgent interim relief. And as I've said, they haven't even issued an application for interim relief. We should have had an application with 3 days notice. We've had no application at all. This application should be dismissed on the basis that we haven't been given proper notice of it. You can only justify dispensing with 3 days in a case of urgency. There's no urgency. There's nothing in the evidence to show there's any urgent need for relief whatsoever in my submission. And that's why we ask you to dismiss this application and make directions, including listing the hearing that my learned friend wants to have.
Yeah, Mr. Craig, I mean, you might, tell me about this urgency and the prejudice that your client would suffer.
No, there's none. There's none on either side.
Yep. No,
Sorry,
well,
Craig,
let's hear from him.
I'm going to address this point. So the only basis upon which this application is resisted is for technical reasons, and secondly, because it said the balance of convenience is against relief of the order, because there's no prejudice to us if no order is made. Now, dealing with that last, we say that is obviously wrong, because first of all, there is no prejudice to Horizon or ABIS if the proceedings in Sharjah are halted while the question of whether ABNIC is entitled to final relief is resolved. They haven't explained why that in any way causes them any difficulty. And as you've pointed out,
Mr. Craig, I don't think I don't think your business. I mean, you will need to look at your interest, your client's interest, whether it's intact or not by tomorrow's action, and tell me how that would prejudice your situation. Like tell me what interests you're trying to protect by tomorrow's hearing.
I will do, but the point about the balance of convenience is one looks that, but one has to look at both sides. So the reason I say that is because that's a very quickly, there is no prejudice to them if the matter is halted. There's nothing, and they haven't explained why it's appropriate for two sets of proceedings to continue at once. There's no answer to that question, and there's no proper basis other than to seek again an unfair advantage against us, that they are seeking to continue those proceedings and not giving the undertakings that we've sought. And one can see that also from the fact that they have refused on 2 occasions to agree to an orderly resolution of this application, and therefore until that's just stop those Sharjah proceedings. Now we do say, on the other hand, there is serious prejudice to us if the proceeding carries on. First of all, it's not just tomorrow, obviously, that there'll be a hearing, but it's what happens next until such time as this application is finally determined. As you know, and you're far more acquainted than I am with all the procedures that are available to a judge tomorrow, but my understanding is he or she could say that the case is sufficiently pleaded and proceed potentially to judgment. They could appoint an expert, which means that the matter is closed, which means that a judge could be starting a process going towards a judgment, which obviously is a problem for the court there if it's completely futile. And secondly, it obviously prejudices us because we are in a situation where a court is proceeding to a judgment or to adjudicate on that dispute. Second point is we have to, I mean, I know it's administrative, we don't have to turn up, but we are being forced, we will be forced if there's a hearing tomorrow.
Sorry, Mr. Craig, for interruption, sorry. As we, in this point, so one of the possibilities that this judge or case officer might, reserve it for judgment. My question is that, is the case fully pleaded before the Sharjah? Well, question number one, whether the case fully pleaded before Sharjah by both parties, and then whether your client have contested Sharjah jurisdiction officially.
Yes, in answer to that question, we have.
Yeah.
We've made it very clear that this is already before the DIFC court, and that's where it should be determined, and it's wholly inappropriate. And it's important to point out, in answer to your question to Ms. Sullivan earlier, about look at which jurisdiction is the most appropriate one. What is going on in the Sharjah courts is that ABIS and Horizon are seeking to avoid the application of the governing law clause, which is English law under the policies. And they are saying, no, you can apply UAE law. So in other words, they're seeking in those proceedings to gain an unfair and improper advantage in those proceedings, which is not contractually available to them. And again, the longer matters go on, the more that those submissions have to be dealt with by both parties, and or the more that the judge goes off on a frolic, effectively, because what will be said by, that it's said that the governing law is UAE law, and so the matter will should be judged by those principles. So if you look at it in the round, and compare the situation, on the one hand, if we hold the position, which is simply what we're seeking at the moment with the interim injunction, no prejudice to either party, because the position is the same as it is today. However, if you do not hold the ring, if you do not grant the interim injunction, then there is potentially very serious prejudice to my clients. But for 2 reasons, as I said. Firstly, because it has to carry on participating in those proceedings, and secondly, because those matters, the court there may proceed to judgment or something else. Is
it in your evidence that the Sharjah local court won't apply English law? Without taking me as an expert?
Would it not?
Is it in your evidence? I said.
That's the position that's taken by ABIS and Horizon. And it's said, and as a matter of local law, unless we can prove it as a matter of fact what that law is, then the court should apply UAE law. So that is, in our submission, a possibility. So in terms of should the court act now to preserve the ring, we say obviously yes, because what if you put it the other way, what prejudice or problem does that cause Horizon and ABIS? We say none, nothing. Now, as to the technical points about the interim anti-suit injunction, we say those are not good points. Firstly, this court has already determined that this application is urgent. Both sides have made submissions in writing to the court as to whether there should be a hearing today, given the hearing in the Sharjah courts tomorrow, and it's determined it should do. And so to the extent that Horizon and ABIS consider this court wrong to do so, that's a matter for appeal, not for re-argument. Secondly, as regards urgency, we say it's clearly urgent because unless Horizon is restrained, the hearing in Sharjah will take place tomorrow for the reasons I've already explained. Thirdly, we say when applying for an anti-suit injunction, there is nothing in the rules that provides it's necessary to issue two applications, namely one for an interim order and one for a final order. An interim order is obviously part and parcel of the application, and that this is so can be seen from the fact that in the application notice we refer to the rules at part 25, which is obviously for interim applications, and secondly we provide an undertaking in damages. The evidence in support of the interim and the final application is identical. The fourth reason is the reason for Rule 25.17 about 3 days notice of an application for an interim injunction is in order to allow the respondent to consider the evidence in advance of the hearing. That evidence was served last week and more than 3 days ago, and the final I see Ms. Sullivan's shaking her head, but the evidence was filed and served on Horizon on the 30th of August, which is more than 3 days ago, and it was served on ABIS on the 31st of August, which is also more than 3 days ago. And
if I may, my lord, I just wanted to point out that evidence in support of the interim application has never been served. They served application evidence relating to the substantive application, but we've had no evidence at all or any application for interim injunction.
Is it the same evidence, Mr. Craig?
No, of course it's completely different evidence.
Yep.
No, we said it's identical evidence. Of course it is, because
the evidence. No,
doesn't matter. Don't fight. I'll find it. I got the registry. I got the record.
Completely different evidence, my lord.
Yep.
And there's no prejudice to that. I mean, effectively, what we're seeking by the interim order is a less onerous order than that set out in the original application. And there is no prejudice to them by virtue of us seeking a less onerous and non-permanent order. And fifthly, we are seeking an interim anti-suit injunction now as a compromise, effectively, to enable the respondents to respond to the application in time before the final application or application for the final injunction is heard.
May I ask you, why didn't you, like I would say, escalated the anti-suit injunction to be heard in an urgent basis instead of going through all of this hassle? I mean, earlier. When did you know about this Sharjah's case for tomorrow?
The case tomorrow, I'll have to take instructions on that.
Well, you should have had it by now. Okay.
If you wait, sorry, if you 31st of August.
Okay.
31st of August was the day we made the application.
I mean, it come to your own knowledge or to your firm or to your client? How the different things? Do you know when your client knew about this hearing, or your local lawyers or whatever?
My understanding is it was the 31st of August.
31st of August.
Which is the day served. So it's just before we. So in other words, it happened after we filed this application.
Let's see. Okay. Okay. Anything further from your side, or shall I turn to Mr. Sullivan for the last time in this application?
I think that's, as I say, I'm going back to the point. We say that the status quo should be preserved. And nothing should happen in the Sharjah proceeding until the application is finally determined. There's one point in relation to the return date, the suggestion when we have the final hearing. I presume we can discuss that after you have considered the. You're
so optimistic.
Sorry, for the return date.
Yes.
Well, I don't.
There
think
will be. I said you are so optimistic. There will be a return date.
Well, no, I don't think there's any dispute that there has to be a hearing of the final application. I mean, there's no dispute that there is a reasonably arguable case.
Well, that's another hearing. Why you call it a return date then?
Okay, well, that would the date for the hearing of the final injunction.
Oh yeah, that's something else. Sure. Yep.
Okay. But to the extent, that you consider that an injunction should be granted now, then it is a question of that it would be effectively a return date for the final application. Or
well,
the final.
Thank you, Ms. Sullivan.
My lord, what my learned friend has just said, it shows why there is no urgency in its application. The first time we knew that what the claimant was actually asking for was interim relief because of what was happening in Sharjah tomorrow was yesterday afternoon. That was the first time. As I've said, they've known about that hearing since the 31st of August. So why did it take them until the 5th of September to tell us that they were actually seeking interim relief because of that hearing? My lord, my learned friend says, well, this is all technicality.
Well, I don't know, Ms. Sullivan, there is some misunderstanding because I recall the registry has approached me. And as earlier, as what Mr. Craig is saying, 31st, and they asked me if I will be available for an urgent hearing. Well, it was not even pleaded, I mean, but I thought he wanted to bring this earlier. I'm not sure when it hits your party, I'm not sure, but I would investigate that from my part. I mean,
no, I'm afraid the registry have been misled. I mean, I think inadvertently, but there's been a muddle, and I'm afraid the claimants are responsible. So what the claimants did, they wrote to the registry last week.
Well, how about not say misled? Maybe confused.
Well, okay.
How about confused?
All right, confused. Well, there's been a muddle. Let's put it that way. I'm not particularly casting aspersions. There's been a muddle. Let me explain the muddle.
Sure.
So last week, the claimant said to the registry, please can we have an expedited application of our hearing, our application for final relief. In other words, the final hearing, not interim relief. And there was discussion about that.
Oh, for the anti-suit injection,
and that is what I think the registry thought it was supposed to be an expedited application of the final application. And that's what we thought the position was until Monday. And yesterday, Mr. Craig served a skeleton saying, oh, well, of course, there has to be an orderly exchange of evidence. And we're suggesting a hearing on the 17th of October. And what we're actually asking for is interim relief because of what's happening in Sharjah on the 7th. So there was a complete change of tack yesterday afternoon. And the registry were told, in effect, this is going to be the full hearing of the final relief, urgent, 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 urgent. Now it turns out it isn't urgent, 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 urgent. It can be the 17th of October. And so they're actually making a completely different application, which is we want interim relief because of what's happening in Sharjah on the 7th. But my lord, they've just told us they knew about that hearing on the 31st of August. So there's simply no urgency to justify going without notice. There's been no notice of this application. Rules exist for a purpose. There's the 3-day rule, and unless there's urgency, but no urgency has been made out. They've known about this for a week. Anyway, but in essence, my lord, so the only question is there an urgent need for an order because of what's going to happen in Sharjah tomorrow? Now, you asked my learned friend, well, what advantage? He can't actually identify what would happen. What prejudice? Well, all he can do is speculate. He can say, oh, well, maybe the judge will give judgment. We're not expecting that to happen. It's completely unreal. If they are seriously suggesting to your lordship that tomorrow there'll be judgment for my clients, they should have made that good with evidence, not just turn up with counsel on the day and make submissions off the cuff. You know, this is an application that requires proper evidence of prejudice. They haven't shown any prejudice.
Oh, no, Mr. Sullivan, excuse me, I think Mr. Craig will show. If we didn't know what's going to happen in that hearing, that is the problem itself. Of one of the possibility, it could be reserved for judgment or appointment of expert, or and quite an effort of things. You know what I mean?
Well, he hasn't said that before, because we've said about at least 3 times explaining that we understand this hearing to be purely administrative, and all that will happen is that the file will be referred if the judge decides it's complete. We've said that. They never engaged with that until 30 minutes before this hearing, when they suddenly said, oh, we don't accept that. And Mr. Craig's come along and said something different. I mean, the fact is, we said it to them, Dave. This is all Mr. Craig at the last minute, just kind of making it up on the hoof. This is not a proper way to pursue an application for urgent interim relief. He says there's no prejudice to us. My lord, the courts never grant relief just because there will be no prejudice. I mean, there's plenty of authority on that. The onus is on them to persuade you that there is such an urgent need for relief that, first of all, you should proceed without giving us any notice, or certainly 3 days notice as required by the rules. And secondly, that they will suffer irrevocable prejudice if you don't make an order. And on that, we say they've dismally failed to show they will suffer any prejudice at all. Simply saying, oh, we're worried about what might happen doesn't begin to discharge the burden. And secondly, as your lordship has already pointed out, even if you make an order, what good will that do them? The chances are the Sharjah court will make up its own mind. You can make an order against us, but we can't guarantee an outcome. And I do want to make a point about undertakings. We were asked for undertakings, but my learned friend has mischaracterised. What they said is, will you undertake to apply for a stay? We said, no, we won't undertake to apply for a stay. He's watering it down now, but that's not what we were asked for. So, you know, this is simply, it's an application for injunctive relief. They have to show serious issue to be tried, which we accept. But they also have to show that there's a basis for the court to intervene. You can't just come to court and say, oh, well, the other side won't suffer any prejudice. You've got to justify the court making an order. And there's simply been no evidence evidence at all to justify you're making the order.
Ms. Sullivan, with respect, just let me, ask you. I like the smile, but because I thought you have lost your temper, or you're so angry, or is that your nature?
Oh no, I never lose my temper. I'm just forceful, my lord.
Oh, that's good. So I thought you were really upset.
No, I didn't. I did not mean any disrespect, my lord. I just speak forcefully, but no, I never lose my temper. I'm quite.
Oh, no. I would love my lawyer will speak for me this way if I'm his client. But I just want to make sure.
I apologize, my lord. I'm afraid.
No, I just want to make sure you're okay. Okay, that's fine.
Yes, it's just my personality, my lord. Sorry.
Yeah, no, I don't have a problem with that. Just make sure. I want to make sure that you're not in a hot seat. Okay.
So, okay. Essentially, I've made my submissions. No urgency.
I think I heard enough here.
No prejudice.
It's all recorded.
Thank you.
Lovely. Yes, I think I will be able to make a decision today. I will be able to make a decision today, maybe in the next 2 hours maximum. Okay. Do you want us to deal with this something else, Mr. Craig, which is the bringing a new party, the joinder?
Yes, if I may. Just to respond very briefly, if I can, to what was just said.
I told you that was here last round, and I'm giving you more round. You have spoken more than here.
Well, my understanding is the normal way it works is that I because it's my application, I have a right to respond to what is said, and there are 2 points that I just wanted to, 3 points
briefly, please,
make very briefly.
2 or 3 now.
Yeah, sorry, 3. First of all, the point about on the hoof evidence. There is no evidence from the respondents as to what will happen tomorrow on the record. It hasn't put in a witness statement, hasn't done anything to that effect.
And therefore, found out about it yesterday.
And so we've put in an email, but Your Excellency knows precisely what happens at those proceedings, so I don't think it really matters. The second point is that we didn't know when we filed our application on the 29th of August about the hearing tomorrow, and it was only once we became aware of that we indicated the need for urgency and we prosecuted things. And thirdly, it said, oh, there's no urgency because look, they're happy to wait until the 17th of October to have the final hearing. Well, that's obviously only in circumstances where this matter is, the Sharjah proceedings are stayed or those proceedings are stopped. And of course, there isn't any prejudice in that case of the matter. So that's a bad point. So that's all I say in relation to that. In relation to the joinder, my understanding is ABIS is not represented at this hearing yet. However, it is a short application, and it's one that can be given on short notice in accordance with the rules. And under what is it, 23.4, this application can be determined on short notice. But what we suggest is an order be made for joinder, but to ensure that ABIS has every opportunity to respond to it, it be given liberty to apply to set aside the joinder with any application to be made by the 12th September.
Sorry, I mean, correct me if I'm wrong. I mean, you want them to, we bring them in as a noticed party, not a defendant.
Yes.
Is that right?
Yes.
And they be noticed by this, they will be subject of this restraining order.
Yes.
Not to pursue with the case or ask for adjournment or whatever do, and then if the case granted it, and then they will be then given the chance to defend it, not today, not before we, I mean, oblige them to do the restraining order until return date. Is that right? That's what you're trying to.
Just to be clear, they would be, even if they're not a party, they should be, or they would be restrained by an order made again that we're seeking, because they are a subsidiary of or an affiliate of Horizon, and therefore caught by the order.
Well, I understand. No. I do understand that. I'm just talking about the procedures. You want to name them as at least a third parties and let's say a noticed party to this application, and they need to be bound by it.
Yes.
Bound by it,
and they'd be joined to these proceedings, but so an order would be made today for them to join these proceedings, but they would be at liberty to put in evidence to say why it is that order should not have been made. In other words, they're at liberty to ask the court to reconsider that.
Yeah, but that in any way it would happen maybe after the hearing of tomorrow, after we have provided the restraining order. Yeah.
Yeah, so the joinder would be made now, but they have the ability to say in due course, actually, we should be joined. Yes.
I see you, but yeah, okay.
Yes.
Yeah, and you're doing this under what rule? When RDC number?
So RDC 23.40.
You may allow me. Well, 2340, you mean? 40? 40?
40.
Let's talk about the preparation for application. Was that the hearing, you mean? Well, it says such application can normally be heard without evidence and not in short. Few notice. What is it?
Yeah.
Is that the one you?
That's the one we're relying upon, yes.
Ordinary application. Application require an oral hearing. Well, maybe this is the reference for the urgency, not for the joinder.
Well, to the extent that you're not happy with that, then we suggest that you look at 23.42, and the timetable for evidence in exchange can be abridged by the court.
Okay, I'll look at that. Or 42. Right, and?
That's it, thank you.
That's it. Well, Ms. Sullivan, I see you smiling now. You have changed your character. Good.
I know.
Let's hear from you.
Sorry.
You're more relaxed now.
Well, I'm always relaxed but forceful at the same time.
That's
so,
right.
my lord, you're aware that we've said if you dismiss this application for interim relief, you should give directions. So that is something I would ask you to look at. I mean, we set out a timetable in our skeleton argument. The other side have set out a timetable, and we're the ones pressing for urgent resolution by next week. And so that's something we'd ask you to look at. And on the joinder, we'd simply say, I mean, why should everything be so rushed for the benefit of the claimant? There's absolutely no need for this, for you to decide the joinder application today. The appropriate time to apply for the joinder application be determined is at the same time as the application for the anti-suit relief. And that will be the appropriate time to ensure that it's, if it's joined, it's bound by any decision on that application. There's no need to do it before then.
Well, we all understand what Mr. Gregg wants, because he knew there is two parties are going to the Sharjah court tomorrow, and he wants to both be subject of the restraining order.
Yeah, but as I say, he's known that since the 31st of August, and he's done nothing about it until yesterday.
And then that's why he's bringing these rules to see the court could have abridged some timetable.
Yeah, I mean, but he should, you know, you can't do that. I mean, you know, you need to persuade the court to intervene. If you sit on your hands for a week, why should the court help you?
Yeah, it's a good question.
Sorry?
It's a good question.
Well, sorry, just an answer to that. With respect, we haven't sat on our hands. we wrote to the court at the end of last week saying this is all now urgent, and we've listed a hearing. We've got a hearing today. So in my respectful submission, there is no sitting on our hands. And could I just make one more point? Sorry, in relation.
No. Could you tell me when exactly you brought the application? I mean, when it's formally lodged before the registry, what exactly? What date? What time?
The joinder application.
The interim relief first, and then the joinder. Yeah, the interim relief.
Sorry, we made our application for the anti-suit injunction
No. The interim relief, the one we decided looking at today.
As I said in our submissions, that is something which is we don't need to make a separate application for that.
It's escalation, you mean?
No, because we're seeking a final order, and we've effectively compromised that to allow for the other side to put in evidence in response to that by saying, well, for present purposes, we're happy to make this an interim hearing.
Are you making interim? You said without an application.
We don't need to make an application for that, as I said. It's part and parcel. It's part and parcel of the anti-suit application.
It's a case management power. That's what you went to the court to do.
Well, it's not a case management power. It's part and parcel of an application like this, we say. You don't need to. The point is, you issue an application for an anti-suit injunction, and that is ultimately for a final order, and that's what we are seeking. But in the interim, depending upon the urgency, you need to have an interim order. That's the reason why you bring the anti-suit injunction in the first place, to stop urgently proceedings going on in somewhere else.
Yes, until the main application is determined formally.
Precisely.
Okay. Oh, sure.
My lord, no. If you want interim relief, you have to make an application. This is an absurd submission. It's like saying you can apply, you bring a claim and then you can apply for a freezing order without making an application. Of course you need to make an application. That's exactly what they haven't done.
With respect, that's wrong. I mean, freezing injunction is entirely wrong, because that is solely interim relief. And so you make an application for an interim order. In this case, we're seeking final relief, and that's the end of the story. And the fact can
I just say, one of the things that the rules say.
There's been orderly exchange of submissions here, but go ahead.
The rules make clear that the application notice should state the order which is being sought. The only application in this case stated that the claimant was seeking a final order. No application notice has ever been issued seeking an interim order. The first time any suggestion of an interim order was made was yesterday afternoon. That's why I say this application is not properly made. No application has been made. No notice has been given. No urgency has been shown to justify the non-notice. because they, as we know, they've known about this since the 31st of August. That's what, as a matter of discretion, my lord, you should refuse this application. It's no way to carry on.
With respect, I think that's a repetition of what's already been said. The order that we sought attached to our application notice is effectively the same order that we are seeking now, save that it is simply on an interim rather than a final basis. The terms of the order are the same, except that in fact slightly moderated, because there's no requirement at this stage for the other side to abandon the proceedings in Sharjah, or to stop them. But the point is, did they know what the terms of, roughly what the terms of the order are? To which the answer is obviously yes, from the time that we issued our application. What prejudices to them by the fact that this is an interim order rather than the final one? None. In actual fact, they benefit because they are given time, and the only reason we're doing this is because they objected to the timetable, and we've said, okay, fine, we'll give you time and we'll get an interim order in the process. So effectively, the interim application is one which has come about by us seeking to assist the other side and enable them to put in evidence in an orderly fashion. So I don't think we can be criticised. And in terms of, so just in terms of the return date, the one question that, and this again obviously goes to how long the Sharjah proceedings may continue before there is a final hearing. We would say that a final hearing should only be listed after the determination by the Court of Appeal of the application in relation to jurisdiction, which is currently before the court. Now that application was filed on the I think it's the 26th or 28th of August. Our skeleton argument in response to that is due on the 16th of September. The Court of Appeal will then obviously need to take some time to consider that application. And so we would say that if the court is minded to put in a date for that final hearing, I mean, the reason I suggest the 17th was to give sufficient time for the Court of Appeal to decide that application, amongst other things. It may be that could be done earlier, say, but in the week of the 3rd of October, which would give the Court of Appeal a couple of weeks to resolve the position, and then this application could proceed. But that goes, first of all, to the date on which this hearing should take place, but also what are the consequences of an order not being made.
But I hope I'm not sitting in that Court of Appeal panel as well.
Yeah.
Well,
that suggestion has been made for the first time. May I respond to it?
sure.
So, it now appears the reason why my learning
By
friend wants
the way, I got your answer. While Mr. Greg's talking, I know from your body language what you're going to say.
Well,
I can summarize that for you.
Articulate what I'm going to say,
No, please, Ms. Sullivan. Yeah.
We now know why they want to push it off as late as October. They want to have the advantage of the Court of Appeal's decision before they have the hearing. But that's not a reason for granting interim relief. I mean, if it's so urgent that they're going to be prejudiced, they should be getting on with it. You know, the fact that they don't want to get on with it because of some other tactical reason of their own is not a reason for you to grant interim relief. Interim relief is quite different from final relief. Final relief determines once and forever. Interim is saying that we should be made to do something or not do something between now and the hearing. And they are completely different things. The evidence is different. Putting in evidence saying you should have a final injunction is not the same as saying you should have an interim relief. The only thing that's being relied upon for interim relief is this hearing tomorrow, which we've got no evidence on at all, and has only been raised yesterday, even though they've known about it since the 31st of August.
Yep. Final remarks? Ms. Craig?
Nothing from me.
It's your turn. I insist. Oh, lovely. Thank you very much. I think I have heard enough from you. Yeah.
Yes, I have nothing further to say. I mean, in relation to that, you understand the point in relation to it'd be better for this court to have a absolutely final decision on jurisdiction before it considered the final hearing. And as I say, it's all about keeping the position, the status quo, preserving the status quo without there being two sets of proceedings carrying.
May I do something before I deliver my judgment? I mean, or my order, whatever, or my opinion in this. If it's work, just tell me frankly. What if you take half an hour, 1 hour between each of you and discuss? I mean, and maybe by engaging your clients, you might reach an agreement. So I might like wait, if you wish. I mean, I can wait for 1 hour from now. You discuss this in deep directly, professional lawyers with each others, and see if you can do something about this application or tomorrow's hearing or whatsoever. Okay, if you can agree anything between you, and then I'll wait for that hour, and then if you be able to reach an agreement about anything, and then I'll be fine. I'll accommodate it. If you can't, you just alert my registry. We kept fighting, we could not reach an agreement, then I'll be fine again, and I would deliver my judgment. If it's acceptable by you, I would really invite you to discuss this. Okay, I don't think it's big things for a professional lawyer like you, QCs, and I think you can deal with it in a blink of an eye. And I'm sure with your experience, you'll be persuasive enough for your backer client that what the best things for both of them. I would really invite you to take this opportunity and even decided from the cost point of view as well. If you would like to take this opportunity, I'll be more than happy. And if you're not, I would not be happy, but I can live with it. Do you want to seek instructions, or you could try?
Yes, I mean our position. We've tried, which is why we've asked them to say, look.
Well, you can try now. You can try now. I mean, forget. I know you've been trying. I know you've been trying. Okay, yeah. I know you can try bring the vessel back from Iran, Mr. Craig, yourself. I mean, but it's
yes.
And yeah, what do you think, Ms. Sullivan? Would you give it a go?
Of course. Of course. I mean, I'm a little bit doubtful because, as you know, as Mr. Craig says, you know, both parties have made suggestions which have been rejected by the other. But of course we can. We hear your lordship, and of course we can. I can talk to my instructing solicitors and see what we can do.
I'll be grateful. Then you know what? I will wait from one of you. Maybe I would ask Ms. Sullivan this time to update the court whether if there is any agreement reached between parties. And if an hour, if you want more time, just ask them as well. But just for today, like extra half an hour, 1 hour. Okay, it's 2 o'clock Dubai time. Is it 9 in England, or what is that? Or
It's 11.
10. It's 11. I'm sorry. And yes, you could have. You just contact my registry. The registry is open for the next 2 hours, where I try to deliver my order. If you can finish things up within the first hour for you. By the way, I'll be studying my application and try to deal with it before I go celebrate my birthday. Okay.
Thank you, my lord.
I'll wait for an update from you, Ms. Sullivan. Thank you, Mr. Craig. Thank you very much.
Thank you.
All the best.